Thank you. Well, it wasn't that good.
They bring out saying.
Wow.
Yeah. Kevin Rob.
Good morning, Your Honor.
Your name?
Kevin Robinson.
There was no accident here, right?
No, sir.
Okay, so you're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that?
Sponsor.
All right, I'm going to accept your plea. 160 is the total. The failure to yield is dismissed. You can go down the hall and take care of that, and you're all set. Best of luck.
Thank you, Your Honor.
You're welcome. Angelina Burke, 26 W843318. Good morning to you. Your name? So you're going to plead to impeding traffic, right? Responsible or not responsible to that? Oh, you're a New Year's baby, eh? 150 is your total. You're all set. I'll accept the plea, dismiss the speed. Good luck. You're welcome. Isaiah Moss, 267843774. Your name?
Morning, my name is Isaiah Moss.
You're going to plead to impeding traffic, right?
That's correct.
Responsible or not responsible to that?
Responsible.
Plea is accepted. 150. It says you need time to pay. How much do you have today?
How much? You gave me how much?
I'm sorry?
I said you gave me how much? You said how much I have today? You said
Yeah.
how much I had like $500 so.
Well, it says you need time to pay.
Oh.
I thought if you got $500, you can pay it all today, right? Total's 150.
150.
You can pay it then.
Yes.
Okay.
And I got something to tell you, Judge. Can you please reduce the fine and give me 30 days to pay because I just got a job, and please.
Wait a second. You just told me you had $500, right? Am I missing something here?
No, Judge. No, Judge. This is my first time doing this. Can you please
Slow down. Why are you reading? Just talk to me. Just talk.
can you please reduce the fine?
No, I can't do that. If I do that for you, I have to do it for everybody
I
else.
just got a job and I should be 30 days notice.
Am I missing something? Did you not just tell me you have $500 with you?
No, sir.
You didn't say that?
I did say yes, but this is my first time.
Do you have $500 with you?
That's in my bank account, man. Sir.
Okay. How much do you think you can pay toward this today?
150, 150, Judge.
You're confusing me. You're asking me for time to pay, but you told me you can pay 150 and that's what the fine is.
I'm sorry, Judge. This is my first time doing this. And I was confused when she asked me how much I pay.
Okay. How much money do you have that you can pay toward this today? We can give you time if you really need time, but it sounds like you had the money with you. That's why I'm asking.
Are you asking me how much money I got in my bank account, Judge? I don't have any money, sir.
All right. Can you pay 50 per week starting next Monday?
Yes, sir.
All right. Pay $50 each week. Beginning August the 10th. That's a week from today.
Yes, sir.
If you don't have the money, it's not a problem. You call the court, you go on Zoom. You have to initiate the call on or before the due date, and I'll be glad to give you an extension, okay?
Yes, sir, Judge.
All right, wish you well. Good luck.
I'm sorry, I understand what you're saying.
That's okay.
I was thinking this is my first time and my parents are not here, so.
Okay, that's all right.
And if you said I gotta pay, like you said, August 10th,
$50 per week, starting next Monday, August the 10th.
thank you, sir.
Have a great day. Ricardo Perez. 2678-42985.
Good morning, Your Honor.
Your name?
Ricardo Perez?
You're going to plead to prohibited parking, right?
Yes, sir.
All right. Responsible or not responsible to that?
Happening?
No, responsible or not responsible?
Yes.
Oh, that's all right. I'll accept the plea dismissed to no proof, $85. Can you pay that today?
Happening.
$40 due now, balance by August the 17th. If you need more time, call the court. I'll give you an extension, okay?
Yes, sir.
Good luck. Thank you. Bosman, Austin, Zane, Bosman, 26 to B 151226. Good morning. Your name?
Austin.
What's your last name?
Austin.
All right, sir, you his brother?
No, I'm not.
Okay.
I appreciate it.
All right, so you're gonna plead responsible to impeding traffic, is that right?
Yes, sir.
All right, to that charge, responsible or not responsible?
Responsible.
How fast were you going? Why were you driving so fast?
I was attempting to pass a car and I was plugging my phone to road.
You're gonna mar your good looking face, you keep driving like that, okay? Slow down. 150 is your total. I'll dismiss the speeding. You're all set. Slow down, please, okay? Good luck. Thanks for coming, sir. Let's just let them miss it.
Just down. Yeah. Yeah. You met ignorance. Better get with who's that? I was to them. Yeah, you did call. I don't know. The road shops over here. Wow. Yeah. Yeah. 84. Stink. All right. Therese Swatolski McKay. 266-48927. Good morning. Your name?
Teresa Rizaldi. Okay.
All right. So you're going to plead responsible to impeding traffic, correct?
Correct.
To that charge, responsible or not responsible?
Responsible.
Okay. I'm going to accept your plea, dismiss the speeding. 150 is your total. You can go down to the cashier and you're all set. Best of luck. You're welcome. John Taylor, 26W843. (711), and then I have another one, 26W843-758. Your name?
John Taylor.
What happened? You get Cited for two,
Yeah, 2 within 24 hours. I didn't know there was, no parking. All the section.
all right, so you're gonna plead on the one, they're going to dismiss the other, right?
Correct.
On the incident 267843711 from the 9th of July, responsible or not responsible? You plead responsible?
Yes.
Please accept the original charges. I'll accept that plea, $85. I'm dismissing on motion of the Department Rep file 267843758. So you can go down the hall, take care of that, and you're all set. Good luck.
Thank you.
You're welcome. People against Katie Fields. Katie Fields, 26T 648945. A and B, your name. So you're going to plead on the no insurance count 2. You're going to plead on count 1, the failure to yield. There was not an accident, right? To that charge of failure to yield on count 1, responsible or not responsible? And as to count 2, no proof of insurance, responsible or not responsible? All right. All right, I'll accept those, please. Do you have the insurance now?
No, I haven't been driving that vehicle.
I cannot drive without insurance. I'm telling you, you'll live to regret that. You get in an accident, the insurance company will pay their insured and they'll come after you for decades. I'm serious about that. 135 on the first charge, 185 on the no insurance. You owe the court $320. Can you pay all of that today? How much can you pay today?
That's the lowest I can pay.
Where do you work at?
Yeah, we're getting students on the question.
Oh,
Want to take the points?
wait a minute. They didn't, you weren't going to plead to impede fair to yield. You're pleading to impeding, right? Impeding and no proof of insurance. I wondered why they was looking at that. That was my mistake. So on count 1, to impeding, responsible or not responsible?
Responsible.
Okay, I'm gonna accept that plea. That's 150, and then I'll accept the plea to no insurance. 185. Oof. You're a bus driver and you're driving around without insurance?
I'm not now, but I will.
How much do you have today?
I get like 50.
Okay, all right. When can you pay the other 100 on the failure to yield? Can you pay that by August 17th?
Next Friday is, that's when I get paid. So this, not from Friday, but
That
next.
would be the 14th, so you can pay by the 17th.
Yeah.
50 today on 945A, that'll leave you with a balance of 100. You have to pay on August the 17th. And on the no insurance, I can have you pay that in full. That's 185 by August 31. Is that good? Yes?
Yes.
If you don't have the money, call the court with go on Zoom. I'll give you an extension, or you can walk up here on or before the due date or what have you, and I'll give you an extension, okay?
So I just go to them.
Right down to the cashier now.
Okay.
Okay?
All right, thank you.
Good luck. All right. Akil Nadavalapil, Shine, 26B151205. I probably didn't do too good on that name, did I? Did I? What's your name?
I cannot do a shine.
All right, so you're gonna plead to impeding traffic, right?
Yes.
Responsible or not responsible to that? Plea is accepted, speeds dismissed, 150, you're all set.
Thank you.
Cashier end of the hall to your right, okay? Good luck. Mary Evelyn Liberadsky, 267-246-596. Good morning, ma'am. How are you?
Nervous,
What's that?
nervous. Are you?
Why are you nervous?
I don't look good.
I'm a nice guy, though.
So,
What's your name?
Mary,
Mary what?
Figuratis.
All right. You all right?
I'm here.
Okay, so you're going to plead responsible to impeding traffic, right?
Right.
Responsible or not responsible to that? Okay, I'm gonna accept your plea. 150 is your total and you're all set, okay?
Can't pay that today.
How much do you have today? Anything?
$50
And when can you pay the rest?
next month. I only receive funds every month.
9, you could pay that on 9/7, September 7.
I'll put me on account for 30 days on this Saturday.
You pay 50 today and I'll make the rest due by September 14th, okay? And if you need more time, you call the court. You can go on Zoom or you can come up here and I'll give you an extension, okay? Best of luck to you. Thank you. Have a great day. Monday morning.
Mm-hmm.
They didn't get enough for school.
No.
I thought they'd do a lot better than that.
Yeah,
Huh?
me too. Yeah.
Ralph Rudy Garcia, 26F246632. Good morning, sir. Your name?
Ralph Garcia.
You are going to plead responsible to impeding traffic, correct?
Yes, sir.
Responsible or not responsible to that?
Responsible?
Please accept it. Improper pass is dismissed. 150 is your total. Cash your end of all to your right.
Thank you, Your Honor.
You're all set. Good luck.
Thank you.
Hickerson. Himasi Dahu Hickerson. 26B151228. Good morning.
Hi, how are you?
Great. How about you?
I don't sleep.
Your name?
Master.
I need your last name.
Yes.
You're going to plead responsible to impeding traffic, right?
Yes, all the way down.
All right. To that charge, responsible or not responsible?
Fine.
All right. You got a prior on here. 160 is your total. Please accept it. Speeds dismissed. 160. Cash your end of the hall to your right. Good luck. Was that Max Clark look good?
Early.
9 them. They haven't figured out his weaknesses yet. Right?
You gotta give him 40 games.
Huh?
You gotta give him 40 games. Is Amy here today? I don't think so. Yeah, I think she's gonna just come in. She's still on.
No, Judge, she's not.
Yeah.
Oh, Mr. Judge. I decided to come back to talk.
About what?
I don't have your file. You're gonna have to wait for me to get your file.
Okay.
Heather, do you know what this is about?
I do
yeah.
not. What was his name again? John's right here. I can give his file to.
Your name again is what?
My name is Isaiah Moss, Judge.
Isaiah Moss.
Yeah.
All right, John's bringing it back down right now.
All right. You can have a seat and I'll call it when I get it, okay?
Thanks.
No problem. One of you guys meet with a police officer? Okay. What department, do you know?
John, he was right across the hall and he told us to come in here and wait in the hall.
Oh, must have been. Were you in the jury assembly room? Is it like a room with a lot of chairs?
Yeah.
Okay. I'm not. Come on up here.
Thank you all. Thank you, Judge.
Isaiah Dwayne Moss, 267-843-774. Your name again?
My name is Isaiah Moss.
So what's up?
So what happened was I was trying to get to do maybe on time with my test, my job. And I'm not a speeding person. I made a mistake and the cops pulled me over. So I forgot to tell you that, Judge. And I was thinking like what you asked me, and I did not tell you that. You know, this is my first time doing this.
Yeah, I know. It's okay. We all make mistakes. It's all right.
I know you cut me off because I was trying to reach to you on my phone and to say, can you please reduce the fine?
You already asked me that. I can't do that. If I do that for you, I got to do it for everybody.
Okay. Thank you, Judge.
Okay. Have a good day.
Judge.
Can't do it. I can't do it. I'm sorry. I can't do it.
This is my first ticket and I don't know points on my record.
I know.
Thank you.
Jonathan Edgar Harding. 26B150176. This is an informal hearing. Semi-truck driver on road, caught fire, no injuries, no other vehicles involved. Your name?
Jonathan Harden?
So you're going to plead to impeding traffic now? Is that what you decided?
Yes, sir.
To that charge, do you plead responsible or not responsible?
Fine.
Okay, I'll accept the plea. This is a commercial vehicle, okay? So it's $230, $235. You can go down the hall and take care of that.
I need a payment plan.
How much do you have today?
I got $20.
When can you pay this?
Depends on when I go back to work.
When do you go back to work?
Say, give me like 1 month, a month, better.
By September the 7th. If you don't have the money, you call the court. We'll go on Zoom if you know how to operate Zoom, or you can walk or drive back up here and I'll give you an extension. Just don't ignore me if you don't have the money, okay?
Yes, sir.
Judge, can we make
235.
can we make the due date, I'm sorry, the 8th, just, we're closed on the 7th.
Oh, is that Labor Day?
Yes,
September 8th, okay?
Thank you.
September 8th. Good luck. Thank you. All right, people against. Nicholas Reed, 26T648921. Your name, sir?
Nicholas Reed.
All right, what's going on? Did you graduate?
Yes, sir.
What are you doing now?
I work at a restaurant at King Staples and I'm an online school for electrician.
Good. So you're going to plead to impeding?
Yes, sir.
Responsible or not responsible?
Responsible.
Please accepted. Speeds dismissed, 150. Go right down the hall and take care of that. Good luck.
Thank you very much.
You're welcome. Marco and Gundick, 26 T648958. Your name? Your name?
Mark Gundick.
How you doing?
I'm doing good.
Do you need me to keep my voice up?
Yeah, I'm hard to hear sometimes.
Okay, so you're going to plead to impeding traffic, right?
Correct.
He's got to write on, he's got to put something else on here, John. Take this back to Sergeant Bernard, please. Have a seat right behind you, right at the table there. He's got to break down minor damage, but. Xinyu Wang. 26T 648-967. Your name?
Xinyu Wang.
Why are you driving so fast at Elizabeth Park? You can't go 37 at Elizabeth Park.
Yeah, I know. I was looking for my friend, so I didn't pay attention.
That's pretty quick. There's a lot of pedestrians there. You got to be careful. They're going to give you impeding traffic. It looks like you got a clean record.
Yes.
To the charge of impeding traffic, responsible or not responsible?
Responsible.
Please accepted 150, cashier end of the hall to your right. You're all set.
Okay, thank you.
Good luck. Right down the hall. Thank you. Mark Gundick, 216-648-958. You're going to, your name?
Mark Gundy.
You're going to plead to impeding traffic, right?
Right.
Responsible or not responsible?
Sponsor.
Says no toes, no injuries, 195. The original charge is dismissed. You're all set. Best of luck. Thank you. Have a good day. You had a younger brother, right?
Yeah, Damien, and I have a brother named Emmett. Emmett and Damien. Emmett passed away last year.
Oh, geez.
My son, Matthew.
I went to school with one of your brothers.
He graduated with Emmett.
I got out in 76, high school.
That's
He
Damien.
graduated with Kevin Nash and all those guys.
No, he was 1 year after me, but he went to Aquinas.
Yeah, he went and played basketball.
Right.
Damien, he's
Last time I saw him, it was on John Wick.
Okay. You guys have a great day.
You too.
Take care. I'm sorry about your son. I really am. It's terrible.
Yeah.
You know my son Matthew though.
Okay.
Yeah,
You
you know,
met
we
school
started high
in
school.
courts, you know.
Okay. Take care. Thank
Thank
you.
you.
Good luck.
Innocent?
Right down at the cashier end of the hall.
Thank you.
Have a good day. All right, we're going to take a recess here, Heather. Who's ready?
Go off the record. Yeah.
All right. Kevin? Your name?
Veronica Lopez.
Yeah, sorry, I can't do this on this one. So you can either, John, take it back to him. Tell him I can't take impeding. If he wants to reduce it to a 1-pointer, I'll do that, okay? You're gonna go back and talk to him, okay? Richard Lamphere, 26W843-510. Your name, sir?
Rich Lamphere.
You're going to plead responsible to impeding traffic, correct?
Correct. So
Responsible or not responsible to that? Responsible. Please accept it. Speeds dismissed. 160 is your total.
okay.
Cashier into the hall to your right. Okay? Thank you. Tiffany King. 260-648-923. Your name?
Joe, me.
All right, so you're going to plead responsible to impeding traffic, true? To that charge, responsible or not responsible? I'll accept the plea, 150. How much do you have today? When can you pay this?
Friday?
Okay, I'll just give you until August the 10th, okay? Oh, that's a week from today, all right?
You want to get complete total?
Well, I thought you said you could pay Friday.
Not all of it, sir.
Tell me how much you can pay and when.
Half of it, maybe.
Okay. $75 due by August 10. When can you pay the rest?
Next Friday, the following Friday. Sorry, I was a little nervous.
Don't be nervous.
Just a little frustrated, that's all.
$75 by August 10th. Can you pay the balance by August 17th? Okay, and if you need more time, no problem. Come in and talk to me, or you can call the court. If you know how to operate Zoom, we'll give you an extension. I'll give you an extension, okay? All right, best of luck. Emmanuel Cargile, 26W843-762. All right, your name? You're going to plead to impeding traffic, right? They're going to dismiss the distracted. All right, to that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, you got 2 prior entries on there within the last 5 years. 170 is your total. I'll dismiss the distracted, okay?
Yes, sir.
Cashier into the hall to your right, Sean Finnegan. August 17th, August the 10th, okay? Can you pay by next Monday?
Yeah.
Okay, August 10th. Sean Finnegan. 26T648-904. Your name? Holding a handheld device. You can't do that. You're going to plead impeding, right? Responsible or not responsible?
Responsible.
Can't do that.
Yes, sir.
$200 is your total. You can go down the hall and pay that, all right?
Thank you.
Good luck. Martinez. People against Lori Ann Martinez, 26T649-708.
Good morning,
Good morning to you. Your name?
Laura Martinez.
You're going to plead to impeding traffic, right?
Yes, sir.
Responsible or not responsible? I'll accept the plea. 150 is your total and you're all set, okay? Best of luck. Gavin Swan. Gavin Swan. 260-648-489. He failed to appear. He's responsible as charged by default. Mark Allen Grant. Mark Allen Grant. 26W843-644. Your name? You're going to plead to prohibited parking, correct? Responsible or not responsible to that? I'll accept the plea. $85 and you're all set. Yeah, sure. How you doing?
I'm good. It was Mike Soto. He didn't know.
Oh, jeez. Take care. All right. Hannah Reed, 26W843-741. How you doing, Ms. Reed?
I'm good, how are you?
Come on up here. Your name?
Henry.
You're gonna plead to impeding, right?
Yes.
Responsible or not responsible? 170. You're all set.
Thank you.
Cashier into the hall to your right, and I will dismiss your speeding charge. Heather Krajewski. 26W84360. Your name?
Other great Steve.
Gotta be careful. All right, you're gonna plead impeding traffic, right?
Yes, sir.
Can you check her on here, please, on the IS system? To that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, $215, cashier into the hall to your right, and you're all set.
Thank you, sir.
Good luck. Maya Caruso, 26W73736. He has that Valdez now file, right?
I gave it to him.
Your name?
I'm Maya. So
You're gonna plead to impeding, right?
yes.
Responsible or not responsible?
Responsible.
Please accept it. Speeds dismissed 150 and your cashier in the hall, okay? Good luck. Diana Kelly? I'm sorry, Joanna Rivette Kelly, 26W8433567. You plead the prohibited parking? Is that what he says?
Yes.
Your name?
Doing Kelly.
And I'm not gonna reduce the fine, I mean, I can't. That's what the intent was, you were speeding, right? Got you going 40 and a 25. The intent of, your name?
Lieutenant Dave told her what he.
The intent of giving her prohibited parking is what? I'm not gonna reduce the fine to $85.
Okay. I was just trying to find something that was a non-moving violation new to the area.
I mean, impeding's a non-moving violation. I mean, it's not even gonna get reported, right?
You're right, Your Honor, yeah.
I mean, I'll give you prohibited parking, but I'm still gonna charge you 150, okay? So to the charge of prohibited parking, responsible or not responsible?
Responsible.
Okay, I'm gonna accept the plea, dismiss the original charge. So the plea is accepted, prohibited parking, the impeding's dismissed, 150 is your total. We're all set. Have a good day.
Thank you.
Rhonda Valdez, 260-151237. I just can't give you impeding with your record, young lady. I can't do it. I can't do it. I won't do it. I'm sorry. You got a drunk driving in 20, you got something else, a speed in 21, another one in 20. Ma'am,
Your Honor, it was an OWDI.
ma'am, whether it's impaired or in OWI, I'm gonna call it a drunk driving. I can't bend rules like this. You got another one in 26, you got another one in 21, you got four.
Another what, from driving?
You got 4 moving violations, including the impaired in 2020. That doesn't qualify you for impeding traffic, so I'm not doing it. So you can either go to hearing on this, or you can plead the speeding 1 to 5 over, which is a 1-pointer.
Yeah, I'll take that.
To the charge of 1 to 5 over, responsible or not responsible?
Responsible.
All right, 170 is your total. and go down the hall and take care of that. And I'm dismissing the improper pass. Okay, good luck. Abbas Ismail, 26W84376, defendant failed to appear and is responsible as charged by default.
Excuse me, she know that someone would watch the plan, she forgot. That's good. What was that?
Where's the file at? What's your last name again?
It's probably still on.
JEW.
Krajewski?
Yes.
Tyler Lee Krajewski, 26W84360. Your name? How much can you pay today?
$40.
When can you,
Started a new job.
when can you pay the rest? August the 10th,
Yeah, I can do that.
a week from today?
Yes.
You sure?
Yes, it must.
I mean, I can give you more time if you need more time. Okay, pay 40 now and the rest by August the 10th, okay? Have a good day. What's your name again?
Tiffany Jones.
Hang on. Do you have a file, John?
It's probably still on.
No, it's not. Tiffany King, 260-648-923. Come on up here.
Excuse me, I know your time is precious.
It's my time isn't that precious. Your name?
Yes, sir, Tiffany Jones King.
So why are you,
Yes, sir, I was really nervous. I paid $75. This is where I really thought I was going
I
to.
wasn't gonna have you pay that till next Monday.
Yes,
You can't do that?
sir, I was facing an eviction and everything.
Okay, listen, relax. Just tell me when you can pay on this. You'll 150.
Can I do 25?
How often? Every week?
Yes, I'll try to do everything.
And when can you start paying on the 10th or not?
I'll try to start paying on, I will start paying on the 10th.
All right, it's $25 due each week, beginning August the 10th, okay? And if you need more time, you call the court, we'll go on Zoom, I'll give you an extension, okay?
Please forgive me if I'm being rude in any way. I just thought this was going to be the actual case that I can come contest it. And I took off from my new job and I thought that I was going to be able to contest it today. And I was seeing the gentleman and I got lost. The directions were horrible. And I took off from my new job, hoping that I don't get in trouble because I just started. And I was going to test it. They said I have to make an appointment and I can't take it off from the new job.
Well, listen, they gave you a break. They had you plead to impeding. He had you going 31 and a 15. That would have been a 3-point violation.
Very grateful. It's just that the car was going the same amount of speed and I thought,
Ma'am, if you want to set the plea aside, I'll set it informal, but I'm gonna let him amend the ticket if he wants. I mean, you can't have the best of both worlds. He wrote you for impeding. It's 0 points. It's not going on the record. He's got you going 16 miles an hour over the speed limit in a 15-mile-per-hour zone.
I just was lost and I was trying to find a gas station. He had taken to the gas station.
I don't know what you're asking me to do.
With the understanding of what you're saying, I'm honored at what you have stated. I'll work this out. It's just a lot. That's all. So very overwhelming
Why is it overwhelming?
to pay money that I already don't have and trying to catch it with everything.
Ma'am, I can give you more time on this if you want. Do you want me to give you more time? I'll be happy to do that.
And you said as long as I'm able to pay, excuse me.
You don't have to start next week. I can start you later if you want. You want me to start you later?
I'm just going to try to.
I'll be glad to give you more time, and then if you want, you can pay it early if you feel like it.
I'm grateful. I don't sound grateful. I'm just frustrated that I got a ticket in the first place, but
You were speeding.
I didn't know. But
You were going 31 miles an hour at Elizabeth Park. Now listen to me. Listen. 31's way too fast, Elizabeth Park. Just this. There's all kinds of people. There's bikers. There's people walking around way too fast.
I didn't even know I was in.
You came out of here unscathed. I'll let you start this August the 24th. Okay? If you need more time, you call the court. I'll be glad to give you an extension. Okay? That's the best I can do. All right? Good luck to you. Thank you.
That's it until 11.
Till 11.
Set.
So I can't do it today because I don't have a motion just in file last night.
I think she can pull a copy for you to work with.
He's got to go over it and look at it.
Yeah. Wasn't even aware it existed.
Trying to see
So I did until last night. Okay.
what kind of jail credit he has.
Well, this offense is May 1st when he got arrested at Walmart. So I want to say 3 months.
He's got 67 days on the shit looks like.
Why don't we bring him out so I can just review with him where it stands.
Okay.
She got all the comments. She and Jamie up there in the comments. They Mike's handling their case. Perhaps.
You know,
That's a bit.
Just keep on coming. 26 CR 1119 is called Daryl Wayne Cooper. You're Mr. Cooper?
Yeah.
Is that right?
No.
All right, we've got 2 problems here you probably are intimately familiar with. There's a theft of property, and it's not a lot. It was a
household tax.
It was food from Walmart.
Walmart, but the problem you have, I mean, it looks like it was about $10. But the problem that you have is because you have so many prior theft convictions, every time if you steal a pack of gum, it's a fail the rest of your life because you have so many convictions. That's the way the law works. Is prior convictions mean people who commit another crime thereafter are held more responsible than people who have not had a criminal history, generally. So my advice, of course, is don't steal. Because every time you steal, it's a felony at the minimum. So that means you're looking at no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you have anything about his probation that you can transform me?
We have the motion that was filed yesterday, Judge.
Oh, great. Okay, let me look at it.
It's not,
You're also on probation for another offense. And a motion to revoke probation was filed probably because of this theft here in this new case. So you've got 2 fires you've got to deal with. And you know that. Mr. Deucer's good man. He can help you navigate through this, but you're going to be held accountable. And
It was fast.
because you have a felony, it looks like there's a felony in this court in 2010. So you're not eligible for probation anytime you commit a crime in front of a jury. Jury cannot give you probation. So in this other case, yeah, a motion was filed this morning to revoke your probation, and this was criminal mischief. You were placed on 5 years deferred or unadjudicated probation back in August of 24. So 2 years ago. And this motion alleges that you violated your probation by committing theft, which is represented in this new indictment, committing the offense of criminal trespass on or about May 1st of this year, failing to report to the probation office on or about May 5th. Were you in, how long have you been in jail? A while? When was he put in jail?
I'm gonna say May 1st with this new theft. Was he arrested?
Was he caught in the act?
Yes.
It's going to be hard to report.
June 13th,
I'm sorry?
June the 13th.
Okay.
He was placed in custody.
So he was still free.
Gotcha.
He failed to report on May 5th. That was before his arrest. He's in arrears of restitution in this criminal mischief case of about $3,400.
That was the original.
Which means, looks like he hadn't paid anything on the restitution since he's been placed on probation for 2 years. But you're stealing. You're committing crimes, but you're not paying what's due. So there are 5 different grounds here of violations of probation. And this is a state jail felony that you were on probation for. So you were looking at up to 2 years in the state jail. And this new case also carries with it a punishment range of up to 2 years in the state jail if found guilty. So that's 4 years in the state jail, and there's not much parole on the state jail. You've got to serve almost all of it. So that's a lot of time. So Mr. Dusler is going to have to work with you to see if there's something that can be figured out. I'm going to reset this until Wednesday. That'll give us 48 hours to look at it and see if there's something that can be done.
I'll get with her. I don't think it was available on Wednesday at all.
Soon, let's have a review this week on.
But I haven't even seen the motion yet. It's just filed.
Okay, yeah, well, there's a copy here.
Okay.
Already in the file. That was filed at midnight.
That's why I haven't seen it.
Well, Mike's working late. Hey, Larry, you filed that thing at midnight. Well, you filed that motion at midnight last night. Wow, what a guy.
Around here.
Look at that. Look at him go.
That was just his internet connection, Judge.
Do you ever go home? Did you ever go
I was
home?
home. I was on my back patio.
Oh, I see. Oh.
Floor in the farm.
All right. So that is Eric Geroy.
There's a courtroom. Thank you. It's starting off. So that's what I'm doing. Oh, that's I'm here's something. I used to go reasonable. I used to never bounce it up on 30 minutes.
Eric Geroy? Is that you?
Yes, sir.
Okay.
I don't know if you have this thing wrong.
Your attorney is here. You need to see that lady. She's going to swear you in. Thank you.
Raise your right hand. You swear or affirm to the truth of the law. Okay. Ink up to the right thumbprint. Place it flat right there on the box. You can have one more time. Place it right outside the box. You just need to try to.
Number call 2060 R1062, State of Texas versus Eric Jason Gerard. Who is present with his attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? We proceed in summary.
Yes.
In summary, this indictment alleges, looks like there's 3 paragraphs here. An allegation of a crime of burglary of a building, and then 2 prior convictions of burglary and a second conviction of assault on a public servant committed in Jefferson County. The burglary, you were convicted in 2008 in the court next door, the 252nd District Court. After that was final, it is alleged you committed the felony of assault on a public servant. You were convicted of that in the 102nd District Court of Bowie County. It's a ways off in 2023. So paragraphs 1, 2, and 3 constitute a state jail felony, but it is punished as though it were a second-degree felony because of the prior felonies. Do you understand how that works? All right, so in summary, again, the state's on or about May 5th, 2026 in Jefferson County, Texas, you committed the crime of with intent to commit theft. You intentionally and knowingly concealed yourself in a building and committed burglary of a building of the Civic Center here in Beaumont. Paragraph 2 goes on to allege that on February 6, 2008, in the 252nd Judicial District of Jefferson County, Texas, next door here, you were convicted of burglary of a habitation. After that burglary of a habitation conviction was final, it is alleged that on or about May 5th, 2023, which would have been 15 years later, you committed the felony of assault on a public servant, a 3rd-degree felony, and that was a conviction in the 102nd District Court of Bowie County, Texas. So again, paragraphs 1 and 2 and 3 constitute a state jail felony, though punished as though it were a second-degree felony. Do you understand how that all works?
This one means got to 40. That's fine. Could be higher. I think that's fair. You have competitive. Yeah.
All right, this means that you are facing a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you would face?
It's sort of.
All right. An agreement has been reached where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment in paragraph 1, charging you with the state jail felony of burglary, guilty or not guilty?
I'm not guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And these 2 prior convictions, burglary of a habitation and assault on a public servant, as we discussed in paragraphs 2 and 3, are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily and because they are true?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered into evidence.
Okay.
Without objection, it's admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses, and you were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived?
Yes.
I'm going to follow this agreement. If nothing further to add, I'm going to find that you are pleading guilty and true to paragraphs 1, 2, and 3 respectively, which constitutes a state jail felony, burglary of a building, though punished as though it were a second-degree felony by the consecutive sentences and convictions in time, paragraphs 2 and 3. You were mentally competent to enter these pleas. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, punished though as though it were a second-degree felony because of the prior felony convictions. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. And of course, you will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
Anything else? I'll say that is fine. Thank you.
Yeah.
We start out with the
She took a file already. I'll put it along with the council. No.
Okay, there you go.
Thank you, ma'am.
So you can address some nothing on the next one. So we'll do this one.
That was on.
Yes, so regular navigation.
Okay, who's up on Balthazar for the state?
Nice. On the navigation.
Well, does he need to be here?
I just think prosecution, so I'm talking to others, and she's gonna have to.
Okay.
And it'll be very good case. That was nothing that confident business. I think it may cause some problems because there's like 6 weeks covered. So they have to be like.
Yeah, that doesn't look right when that happens. Well, we'll bring Mr. Balthazar out. We're going to explain to him where things are. Have you talked to him at all?
I did.
Okay, where's this headed generally? What does he want to do?
It's probably headed in the direction of trial. So
Oh, okay. What are you eating? What are you eating? And that's a crunchy thing.
it's delicious.
Is it? Certainly isn't pudding, I'll tell you that, because that thing crunches.
Your quote for her always, it's the best candy.
Come on out. Are you Mr. Balthazar?
Yes, sir.
Okay. Yeah, here in 24 CR 127, you are on probation and there is a motion to revoke probation that has been filed. And it alleges you committed the offense of unlawful possession of a firearm, deadly conduct, discharge of a firearm, failed to provide verification of performing community service hours, and failing to submit to alcohol and or drug screenings. Okay, one or more violations of probation, that's enough if found true beyond a reasonable, by a preponderance of the evidence or greater. That would be enough to grant this motion to revoke probation, and your probation could be revoked and you could be sentenced up to 2 years in prison. There is a new case that's been filed, it's new, it's May 20th in 26 CR 9A2, which alleges that you committed the 3rd-degree felony of deadly conduct, discharge of a firearm, which I am presuming, since it has the same date of the event in the indictment and there's the same date of this allegation, that this must be what is alleged in allegation 2 of wrongdoing in this motion to revoke probation.
That's correct.
And there's a offense unlawful possession of a firearm on that same date. Was that filed? I don't-
That case was. I don't think so.
Okay.
It's not that
So you have a new indictment and the motion to revoke probation. You understand? Yes, you have to speak out so she can hear. Okay, thank you. Okay. Mr. Eckert here, who's a fine lawyer, is unable to represent you because he had something to do with the prosecution here in the beginning. So that makes it problematic by law. Are you able to hire a lawyer? No, you're unable to hire. Sure, it's got an indigent form because somebody's going to be appointed to represent you. Okay. Let's make sure that. There was an affidavit of indigency way back when on 22 on this. Well, what I the last affidavit of indigence that's in the record is in 2024. So I'm going to ask you to fill out another one so we know what your financial status is. If you're unable to hire, then we'll get you somebody appointed today. So that's the first thing you need to do. And I'll put that affidavit in each of these two files. And then somebody will be appointed to help you, okay? So just get that done. Thanks. And we'll bring you back up and we'll tell you what directions we're heading next. Thanks. It's Mr. Wiley. All right, you're released. Yes, sir.
Orders about the child. I think I'm on the phone with you.
Yeah. Yeah, James Patrick won. And then Marvin Lewis with Nichols is 2, then Wilkerson is 3, then Tepe and Johnson with Burbank's 4, and Wilkerson. You ended up 6, but you never know. Sometimes they may fall like dominoes.
We're just posting of it.
See, you moved up already.
I'm excited, Judge.
Mm-hmm. You tell. Your toes look like they're tingling from here.
Have you moved up? Have you moved up?
Taylor Jackson, Brian.
Here.
You certainly look like it. Looks just like you. Taylor.
Told me a couple of things. It's all good.
Who are you? Taylor? Okay. 24 6261. All right. There's hardly another more serious type of offense than what's alleged here. And it carries with it up to life in prison if found guilty. So.
What?
What are we doing today?
Me and Ms. Moore are going back from where she was at a seminar. There was some notes left. We missed her there if we can ask it for a second.
This was indicted on October 30th of 24.
Yes.
And it's going on 2 years on a aggravated sexual assault of a child. I get in trouble for that.
There was a certification, juvenile certification had to go through
2 years.
It took a lot of.
Well, this is fast track and it's going to move real fast to try. We get ready, everybody, because.
Mr. Stover, right? Represented by Mr. Ocello. We have Mr. V from the prosecutor's office and Officer Vidger from Community Full Court Services. We are here today for a review hearing. The court is in receipt of the report from Summit dated July the 22nd, indicating that Mr. Stover remains a mentally ill person subject to hospitalization with the least restrictive treatment alternative being admission to Summit. Report indicates that Mr. Stover still continues to lack insight into the seriousness of his substance use disorder and for the benefit of medications. It's my understanding there's a stipulation to the report and to the contents, but not necessarily to the conclusion. Is that accurately stated?
Yes, right. Yes, right.
All right, anything additional from the state? Mr. View?
No, Your Honor.
Mr. Ocello?
No, Your Honor. Thank you.
Mr. Stover, anything you want to tell me? All right, court finds that you do continue to remain a mentally ill person subject to hospitalization, and I find that the least restrictive treatment is a commitment to some behavioral health, and we will review this in 6 months. Anything else?
No, Your Honor. Thank you. Yeah, thank you.
All right, that's all.
If you'll do the entry, Your Honor.
Yes.
This isn't the way the legislature intended these allegations to fester when it's a child. Let's see, what's an 11-year-old and an 8-year-old as allegedly the victims. Okay. Yeah. But what are we here today? What are
That mentioned something about, but we just have a minute today. We just have a minute. We'll talk. I'm going to check something out here.
Okay.
I got to look at some notes. We got
This is going to get on the trial docket, and it'll be placed at an accelerated time period. This is the way the law requires.
You are number one.
I'm number one without ever said.
So,
Judge Home.
hey, Brian, I'm looking here. There's 5 separate cases, right? You've got 5 separate cases. Okay.
Yeah.
Okay. Get with him on how y'all are going to do that. Those get one at a time, and so they wear everybody out, but and they get stacked on top of each other.
That doesn't show
As punishment.
but I get
The way that's why those deemed them some of the most serious infractions under criminal law.
Their Balthazar, so we don't have to do it.
Mr. Bassel? Yeah. Come on out.
I haven't sworn to it yet.
Okay. I'm gonna find you indigent here, but she's gonna swear you as to these allegations. This statement, this affidavit is all true and correct? So help you God, right? All right. In front of her?
Okay. I just need the right to write down the swear or affirm the information that has been true and correct. Okay, you can go back. Judge Hoover explaining this.
No, he's got a conflict.
So just someone else will. Okay.
Yes.
Yeah, so they need something else. Yeah. Is it on?
James, you're first for trial.
May I approach your honor?
How could I be personally? I've never set a case for fraud. We were in here last time.
It's on the trial docket.
Your Honor, we were in here last time and Mr. Elam was reset because he had 2 new burglaries and you asked him if he was going to hire me and he said, yes, I am. And of course, no, he didn't. I've been communicating with him the whole time, but
How did he get on the trial docket with your name on it?
Well, I've never.
That's all I'm saying. Yeah,
We've never stood.
I got 5,000 cases, so all I can.
We've never had a plea at all. We've never.
You were in court. That's why it's on the trial docket.
I did not put your honor, as an officer of the court, I've never placed this case on the trial. Communication with Mr. Elam has been.
An issue, Judge, if you have these dockets out ahead of time, and I'm always available to help work things out.
Well, when we were in here last time, I'm not trying to interfere with the courts, and I apologize if it seems that way, but Mr. Elam stood right here last court setting. And
again, 5,000 people. I'm going to have to trust what you're saying, but look, there it is. I didn't.
No, I understand. I got the notice. I understand. I do understand.
That's, I'm just
when it was emailed to me, I mean, Ellie emailed it to me, but again, you would reset the case because Mr. Elam was arrested on 126 on 2 new burglary cases. Or 1 burglary and I think another misdemeanor. And we stood right here and Mr. Elam said, I want to hire Mr. Patch. He said, well, are you going to hire him? And of course, I didn't know because he doesn't communicate with me at all. And
so you don't represent him.
I do not represent him on the other case. I mean, I've got a state jail case I'm representing him on. But he has a burglary and
theft of the firearm.
I'm sorry. He has a theft of a firearm case. That's what I'm representing him on. But he also has a new burglary case that he was arrested on a warrant on 126 when we were in court.
Okay.
In court 3. So
we came in here.
We came in here a few months ago. We've never entered a plea on the case. You reset the case for him to hire me on the burglary for us to try to work it out.
So
never hired him.
What are we going to do and when?
Well, I'm here prepared. He's never communicated with me on this state.
What are you going to do?
I'm ready to go.
What direction do we need to do?
That's going to be. I need to speak to Mr. Elam about that.
Where is he?
He should be here. Right. Probably best if he comes up here.
He can't read your mind.
Just like we did last time.
Y'all got to communicate.
Yeah, he did communicate with me. He told me that he could not hire me on the burglary case. And I said, well, I'm representing you on the state jail case, but
yeah,
we stood before you on.
We don't have to try both of them at the same time. I mean, we'll try one and then the other.
Well, that would be good.
What are y'all ready? When will you be ready?
I don't know how he wants to plead on this case because we have not talked about that because of the new burglary case. He understands the discovery. I've explained all that to him.
Okay, but it's over 300 days old.
Your Honor, I was hired on. We were in here on 1/22 of 2026. He was arrested on
6 months
misdemeanor court. That's exactly right. He was arrested on 123 out of court 3 on his misdemeanor out of the same transaction. And then here we came back in April and we stood here and you said, okay, get with Mr. Paget and hire him. And we got a date and we left, but we never,
never hired him.
I'm sorry?
I ain't never hired him.
Mm-hmm. Well, we know that. We're getting to another point, but we never.
Your failure to move on your own and get something done on your own behalf is not going to stall us. We're going to move forward one way or the other. If you can't hire him, then if you're unable to hire him, we're going to get somebody appointed to represent you, but we're going to go to trial. We're not going to wait for you in 10 years or 20 years whenever you decide you're ready for trial. That's not the way it works. Do you understand? Yes? Okay. If you can't hire him, let me know. Somebody will be appointed to represent you and you're going to interrupt. You get a chance to talk. We can't both speak at the same time. Both 2 people or more speaking at the same time.
On that burglary case, we did appoint Langston Adams to that burglary case for him. So he does have representation on that other case.
But how did this one, how did James's case get on the trial docket?
Your Honor, I can assure you that.
Let me ask her, see how she did, because
I did the same thing.
I don't want you to come up when you don't need to.
But Judge, I don't remember. I just looked, he sent out a reset on April the 29th. and it was a setting for trial docket. No one has reached out and said it was an issue. So I can't tell you how it ended up in the trial docket. But no one's brought it up.
The court gives me, if we're gonna, shouldn't I stand here and say, yeah, Your Honor, my client pleads not guilty of the case and we request.
You would think unless.
Well, there's a record and I'm sure you that never happened.
The only time it wouldn't is, yeah, we're supposed to be here. Nobody showed up. So.
No, sir, we were definitely here.
Let me finish, James.
Yes, sir.
The only way that would have happened otherwise would have been y'all didn't show up. And then for an announcement, and then we just defaulted it onto the trial docket. But you would have been told that. We wouldn't have got you 4 months later. Somebody would have said, you didn't show up. This is what we did. What do you want to do about that? Do you want to move forward this way or not? I mean, that's the way we do things. I don't know.
Just you want to just pull the docket
and pull the record.
Yeah, we don't sabotage.
You know, I understand that's not the court.
But you're not ready for trial, is what you're saying.
I mean,
okay.
All right. Well,
you know what? That's why God invented a number 2 slot.
Well, I mean, like I said, I understand the court's policy and I respect it, but it didn't happen in this situation.
Yeah, once again, it's 5,000. I got 5,000 and I just.
And I have all respect for the court and what's going on
here in this thing. So if you're not ready for it, that's okay. We can move it and figure out what he's going to do and how he's going to do it.
Before we have a trial setting, I would like to hear whether my client wants to plead. I've reviewed discovery with him. He has never told me what his wishes were. Because of this new case, you reset it for several months.
Well, did you want to put something on the record? What he wants to do? Or
are you prepared now to tell me? Well, he has a burglary case too that I'm sure he would probably like to handle these cases together. He's never indicated to me that he wanted to not.
Or you helping him on the burglary?
No, I haven't discussed it because he was supposed to come to my office, to make an appointment and hire me on the burglary case, which he's communicated with me by text and said, you know, I'm trying. And then a few days ago, I think you texted me and said,
we just don't wait though. It's like a train. It takes off.
And you're
not on the train. You got to run after the train, which nobody can catch.
Is this pretty much what I told you, that we had to move forward and the judge is not?
I mean, other than
No, it says reset for trial on that, but that's all it says. There's nothing else.
That's fine. So
nonetheless,
so I do not.
What are we going to do then?
Well, what I would like to do, if Mr. Langston, Mr. Adams is appointed to him, I would like to.
Is he?
Oh, that's what.
Judge.
He's represented and paid on the.
Hold on, when did Langston get up on?
No, cross your arms, your hands down. It's okay. Speak up, stand up, and talk. Look off. Look right here, okay? Because
we're moving forward on the trial. That's what you want. You're going to move forward. We got to figure out which lawyer.
We need to see whether he's indicated.
Well, but you've got an obligation to also communicate with the people who are apparently representing you.
What I would like to do, Your Honor, is I would like to.
Everybody has that same obligation.
Sit down with my client, and then I would like to speak to Mr. Adams once he has an opportunity to review discovery and get a response from my client. I'm more than willing to go forward either way.
Okay. Well,
hired on
whatever. It's been months since obviously something's been done. Let's move forward. You know,
I think you gave him that much time to give him an opportunity to hire me, Your Honor. He's been unable to do so. And again, I don't want to hold up the court as quickly as Mr. Adams can.
Langston was appointed on the burglary case 1/23/26, so right after he was arrested.
Yeah, 8 months ago.
You said 122 or 123?
123.
Yeah, that makes sense. He was arrested on 123.
And you haven't even talked to him?
I don't know what that is. I ain't never get his contact information.
Listen.
And Langston was here as well on that burglary case on April the 29th.
And we were in court on April 29th.
Yes, he was with both of his attorneys.
Look,
so Mr. Adams
it's reset 1 week. It's reset 1 week, get a resetting. And
I'm fine. Give me a week. I'll be ready to do whatever we need to do.
Cases.
Could you give me a little bit longer?
That's just an announcement. So see where we are.
Give me enough time to subpoena.
both cases, so both lawyers are here.
Status update.
Yeah,
I
that's
just
what
want to make sure I have time to get my subpoenas out.
Okay.
If he wants to try.
So that puts Marvin back. Marvin Lewis with Javante Nichols is.
You need to contact Mr. Adams. Do you have his phone number?
No, I'm back.
Lacey, is there any way we can?
We're going to alert him to be here.
Because I don't want to stand up
So
here
y'all
again
both can
not be ready.
figure out with him what's going to
I'm
happen.
ready to move forward quickly as well, Your Honor. This is, I'm not.
It's fine.
A little bit.
That were things that he's needed, right? You know what I'm saying? They give you, Mr. Adams contacts you, you need to get with him. We've only got 1 week. Do you understand?
Okay, here's some, another case.
Okay. This was so we went from one side from there. I don't know if they feel pretty stuff. It's all happening.
Really, do you make one?
I'm not waiting for this. You know, the only word for it is
I'm assuming this,
I'm not waiting.
Could you tell me that's all sexual and offer there and it's communication issue for
That's what they, I'm for 30 years.
is Drummond Balthazar still? Is that you? Drummond Balthazar? Is Drummond Balthazar still here? Here, that's the indigent affidavit that was signed.
I'm sorry.
It's also.
It's legalized. Don't run off, okay? Don't run off.
Right. What's up on Taylor?
I think, my brand notes from this one. It's going to be a. Oh, the thunder here.
Okay. All right, on Taylor Jackson, where's he?
He's right here.
Taylor Jackson, we're going to set this for trial, and it will be fast track because of the nature of these cases. And it will be the most serious one first, and then we'll do one at a time, over and over and over again, until we're completed with these. And you're looking at aggravated sexual assault of a child of first degree felony, aggravated sexual assault of a child of first degree felony, another first degree felony. Three. There you go.
Presented by Mr. Gibbs. We have Ms. Trainer from the prosecutor's office. We're here today for a pretrial. It's my understanding Ms. Dees is going to be entering a plea of guilty to 1 count of possession of drugs, and we're going to set this for sentencing. Is that accurately stated?
Yes, sir.
Yes, sir.
Ms. Neese, how old are you?
51.
How far did you go in school?
Graduated.
Are you able to read and write English?
Mm-hmm.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
No.
Are you a United States citizen?
Huh?
Are you a United States citizen?
Yes.
If you enter a plea of guilty to this charge, I'm not going to sentence you today. I'm going to conduct a level 2 pre-sentence investigation and set this for sentencing in about 8 weeks. I've told Mr. Gibbs it's likely that I will release you from jail when we come back for sentencing with time served. I don't anticipate this is the kind of case that I would send you to prison for. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry on the second page. There's a signature above the line defendant. Is that your signature?
Yes.
Did you review this with your lawyer before you signed it?
Yes.
Are you satisfied with the representation that you have received in the case?
I got a kid back home I need to get to, but
Okay, well, I think,
he's 14. He starts school tomorrow. And
so my question, I know that the outcome that Mr. Gibbs has achieved for you in this case is not exactly what you wanted, but is there anything that you want him to do that he hasn't done? Other than get you out, which is not happening. This is a 2009 case and you have failed to appear repeatedly. I am not releasing you from my custody until we are finished with you. That doesn't matter who's standing next to you at that podium. That rule's not going to change. You understand that?
okay.
You're going to be entering a plea of guilty to 1 count of possession of drugs. It's a 5th degree felony punishable by up to 12 months in prison, $2,500 fine. There is no mandatory prison in the case, but if I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yeah.
Ms. Trainer?
Your Honor, this offense occurred February the 3rd, 2009, Warren County, State of Ohio. The defendant on that date was in possession of a Schedule II controlled substance, being methadone, in an amount of 0.50 grams.
Anything on those facts, Mr. Gibbs?
Nothing further, Your Honor.
Ms. Deese, did you hear those facts? Did you hear the facts that Ms. Trainer just read into the record?
Yeah.
Do you admit that those facts are true?
Yeah.
Do you understand the rights you're giving up by entering a plea? Is that a yes?
Yes.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. We're going to do a level 3 pre-sentence investigation, see everybody back here in about 6 to 8 weeks.
And Your Honor, if I may address briefly, just
sure.
I understand you said you're not releasing my client. I just wanted to put out a request for consideration of a bond in place, possibly with GPS or EMHA or something to that effect, Your Honor.
Yeah, I mean, we gave her a bond, which was surprising on an old case, and she did not report to pretrial services the next day, and it's just been a pain, so I'm not going to do it. So we'll see you at sentencing, Ms. Neese.
'24, I believe you said. I don't know what to tell you. I don't control that judge's docket. But I can't.
This is the one I just gave them,
Which each of them carry with them up to life imprisonment, which can be stacked on top of each other, and then you've got an unauthorized use of a motor vehicle, state of felony, which is actually the least of these problems. And then a 4th aggravated sexual assault of a child. So those are the first degree felonies, carrying with it up their lives. And then the state jail felony. Jackson said him as soon as we can get it done. Thank you. That means it's getting done quickly. Yes. And on this one, hey, Brian, there ain't no deal now. This is it. There's no deal. Okay.
Yes,
He's racing. Can you start walking off of that? Yourself, you got?
I wanted to apologize.
You got your white number?
Disrespect to you.
You didn't.
I didn't mean to speak over you again.
You're fine.
I was just.
That's a family.
That's good. The 3 month old.
I know. I hear, yeah, that's a water.
James going down.
Oh,
she's going fast.
I haven't seen her.
She's going to be 98 here in a few weeks. And you know what? She's going down where she wants to go. Everything's going real slow. She's comfortable.
She's comfortable. Different time goes by, and I haven't talked to her in years now.
I'm gonna tell her you ask him.
Please, because
She talks about her dad all the time.
yeah, she's the sweetest. She's one of the sweetest ladies I ever. And
She's not sick.
well, that's important. But I just wish I wish somebody like that could live forever.
I know, but you know what? She's a regular.
Really.
And the other kids, you know, we're coming for.
It's funny. It's the way nature is. I think for people know, and if
She's comfortable. She's happy. She was like shower. She sits in her chair.
well, she can't do some things that she enjoyed doing, and that's
He doesn't want that. She's ready.
well.
She's happy. That's what she says. I'm fine, my baby. So anyway, I thought,
Okay, thanks. Thanks, Dan. You just,
I mean,
so don't worry about that. You don't need to ever look at somebody.
never.
If I you're just be vigorous in your representation like you are. Hey, Reagan,
Yes, sir.
what were you gonna do?
Oh,
Do you need to see me?
well, yes, sir. I just wanted to finish up this plea on Butler so I can go take care of my others.
Okay, let me do him. Okay, so come on up.
That was on.
That's Jean-Claude.
Yes.
$25 CR 34 is filed. Jean-Claude Butler, that's you? With Mr. Wilkerson, your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and the arraignment here. And we proceed in summary.
Yes, sir.
In summary, this indictment alleges that on or about November 2nd, 2024, in Jefferson County, Texas, you committed the third-degree felony of injury to a child. Oh, in this case, it's an elderly person.
Yes, sir.
The statute states injury to a child, elderly, or disabled person. It's all dealt with in the same statute. So this is an individual 65 years of age or older. You understand what you're charged with here, sir?
Yes.
This is a third-degree felony, which means if convicted, you face a term of not more than 10 years or less and 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? This agreement's been reached in your case where you would be pleading guilty, but not found guilty. You would be placed with deferred or unadjudicated probation, which is up to 10 years in length. And there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that?
There's also, he also is to be placed on mental health caseload.
And other terms and conditions of probation, which are particular for your situation and circumstances. Is this your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Defense will wait. Yes, I have.
This is with the approval of the family. There's some issues of mental health with this gentleman.
But he's not incompetent.
He's not incompetent. No, sir, he's not.
You still don't. It seems for me. So that's. What was that? What was the person? 84 years old? 85 years old? So you're not incompetent, you're not insane. So you struck this lady in her face, and it says suffered visible bodily injuries and felt pain. And the assault was captured on video.
Yep. Actually, Your Honor, we did file a motion and a notice of affirmative insanity defense. However, in the interest of justice, we believe this plea appropriately resolves the matter. So just for the court's information.
Okay. But still, you hurt an elderly person. They're special. It's like hurting a child.
Oh, no, no, temporary psychosis.
All right, we'll try this. What did you decide, Mr.
Well,
temporary psychosis?
Then we need to get an order on the motion and notice that I filed in July, Judge.
No, I'll have a hearing on that on Wednesday. I don't have time right now. I got other things, okay? Thank you.
Hearing what? Hearing motion affirmative defense and standing.
That's for jury. So what was that? We'll figure it out. I don't know. Is it?
Okay. Next. Reagan. Ray Britton.
He's a plea judge.
Here's this. Being from that. Nice. What are we doing here? There's two cases.
Yeah, it's a plea to 1340 and the other cause number will be dismissed.
Come on up, sir. Please sign in front of this lady. Thank you.
It's written, please raise your right hand. There you go. You just throw all right shelves. Okay, you hit the right thumb first, right thumb. Place it flat on the box right there. Right there. Okay, you get it one more time. Place it flat right there.
Okay, you are Ray Sean Britton. Yes. In 25 CR 1440 here with Ms. Nowby, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed?
Yes, Judge.
In summary, this indictment alleges that on or about August 25th, 2025 in Jefferson County, Texas, you committed a third-degree felony of injury to an elderly person, somebody 65 years of age or older, which seems to be a case du jour here on the docket. It's not the first one. Do you understand what you're charged with here? Is that yes? This is a third-degree felony if convicted, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements been reached where it would be pleading guilty but not found guilty. It would be placed on deferred or unadjudicated probation, which can be up to 10 years in length. Looks like 3 other cases would be dismissed.
2 misdemeanors. Yes, Judge, and 1 felony.
Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
What is it?
How do you plead to this charge, guilty or not guilty?
All
right, we go to trial. That's
Man.
Well, you just said not guilty.
Oh.
Judge, we discussed this in the back. I think he's a little nervous just being before you. We discussed how this.
Well, these are 2 easy words, not Guilty, and
I believe that's, I'm surviving.
okay, is that your final answer? That's what you meant to say?
Yes.
Okay. Ah. Have you ever been convicted of a crime before? No? Okay. All right. So this is a first time, and you don't understand the way this can work. Okay. So that's your final answer. You are guilty of this crime. Yes, you have to speak out. So
Yes, sir.
All right. Are you pleading guilty voluntarily because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence. Without objection, it's admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
Okay, State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I'm going to follow this agreement, sir. And I'm going to find that you are mentally competent to enter this guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But we're not going to do that. We're going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation of this probation order. As long as you do this, you won't be found guilty. If you fail, your probation can be revoked. You can then be found guilty and sentenced to up to 10 years in prison. Okay. What's the length of probation? Y'all had something on the side. What do y'all want?
I don't care about 5 days, that's fine.
All right, I'm going to place you on deferred or unadjudicated probation for 5 years. There will be these terms and conditions of probation. The probation officer will go over them with you. Make sure you follow them, because if you fail, your probation can be revoked, and then you can be found guilty and sentenced up to the full range of punishment.
Since you dismissed on their rejected.
I don't understand what in the world was this little temper tantrum all about? Oh, because I'm reading this, and this isn't for an adult. Adults shouldn't act this way. You're acting like a little child. Was that a one-time thing? It won't happen again? Yeah, that's embarrassing. This is embarrassing to read this out. It would be like a little 9-year-old having a temper tantrum, which you're a lot older, you're an adult, act like it. And the relationship to this person was who? Your grandfather. Your grandfather. What do they call those people? The grandfathers? Why do you think it's named that? They're not a bad father, but a grandfather. You're supposed to treat them with respect. It's because they've earned it. Fix that. Don't do that again. Make sure that understand and appreciate the importance of family. Because that's all the family you got. The family that is the Creator gives us, and so you gotta, same kind of blood flows in the veins of families. There's a good reason for all of that. Okay, I have a 25 CR 1705, a motion to dismiss. Any objection for me signing this?
No, Judge.
It is hereby dismissed. Please see the probation officer. Thank you.
I'm able to see you're going around back. Yes, so I know it was significant. That's all.
That's Reagan. Get comfortable. That's what you have. I have.
I think they assigned us.
Centarius Davis.
He's a plea judge.
You got one who was like that, so
Get all the read. I have these. I dismiss.
Yes.
So we're going to dispose of 4 cases.
I'm not coming back. So he's more trial, I'm going to go on murder is the facts. So. There's a giant door, you know, so don't worry about it.
Yes.
All right, come up, sir. You're Mr. Chavis, right? Okay, you need to sign in front of that lady. Thank you.
Mr. Tate, please raise your right hand. Sir. You should have right hand. Two seven that.
Yes, ma'am.
Either your right hand. Place it flat on the box. Okay, way over than that again. So again, place it right on the box. Okay, one more, different side. You're imagining that they must have.
No, the older I get, the worse my hearing.
Thank you.
What'd you just say? The older I get.
Then you're going to comply with the order of the court and the recommendations that were completed by the assessment. Is that clear?
Yes.
All right, so all the other orders are going to stand, but they're going to find a bed for you and you're going to go into residential treatment that was originally recommended. Ms. Tranter, is there anything else I need to do?
No, Your Honor.
Ms. Diefenbach?
No, sir.
All right, let's get this right, okay? I'm trying to give you an opportunity to help yourself here, so let's get this taken care of, all right? All right, that's all. A monitor, EMHA.
I walked right into that one again, Judge.
Okay, we have Centarius Marquise Chavis. So I've got 4 cases. Which one? The one is to be dismissed. Let me pull that one.
288, I believe, the one ending in 288.
Okay, 26 CR 288, unlawful possession of a firearm by a felon. I'm going to put that one just aside. Then we have 3 in numerical sequence. 26 CR 750. This is state jail felony, evading arrest or detention. Then 26 CR 751, 3rd degree felony, unlawful possession of firearm by a felon. And to round out the field, 26 CR 752, the 2nd degree felony, the aggravated assault with a deadly weapon.
Correct, Judge.
Okay. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, Judge.
In summary, sir, 26 CR 750. The first one in numerical sequence alleges that on or about December 1st, 2025 in Jefferson County, Texas, you intentionally fled from a person you knew was a peace officer attempting to lawfully arrest or detain you, evading arrest or detention, and that happens. But paragraph 2 goes on to allege that you have previously been convicted in County Court of Law 2 of Orange County, Texas for evading arrest. So paragraphs 1 and 2 thus constitute a state jail felony because of the prior conviction. So anytime you evade arrest, it's always going to be a felony now. You're looking at no less than 180 days up to 2 years in a state jail, and a fine up to $10,000 can also be assessed. Do you understand the punishment range applicable in this case?
Yes, sir.
agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in prison. And that, I'm sorry, 2 years in a state jail.
Yes.
And that would run concurrently with 2 other cases. Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this indictment? Guilty or not guilty? And to paragraphs 1 and 2, by the way, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And this paragraph 2, which alleges that prior 2020 conviction of evading arrest out of Orange County, Texas, is that allegation true as it is alleged? And are you pleading true and correct to that voluntarily?
Yes, sir.
All right. Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty pleas freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report right on this?
Yes, Judge.
On this cause number 26 CR 750, state jail felony of evading arrest or detention with a prior conviction of evading arrest, I'm going to find Mr. Chavis, you're pleading guilty and true respectively to paragraphs 1 and 2, constituting a state jail felony of evading arrest or detention. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. And this sentence shall run concurrently with 751 and 752 that we are about to go into. Do you understand what has happened here in this case, sir?
Yes, sir.
All right, we now go into 26 CR 751 and 26 CR 752. And again, lest the defendant wait formal readings of these 2 indictments, can we proceed in summary?
Yes, Judge.
In summary, 26 CR 751 alleges that on or about December 1st, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of unlawful possession of a firearm by a felon. Do you understand what you're charged with there, sir?
Yes, sir.
And 26 CR 752 goes on to allege that you committed on or about December 1st, 2025 in Jefferson County, Texas, the 2nd-degree felony of aggravated assault with a deadly weapon, namely a firearm. So do you understand what you are charged with in these 2?
Yes, sir.
In 751, this is a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand?
Yes, sir.
Agreements been reached in that case where you would be pleading guilty, sentenced to 5 years in prison to run concurrently with other cases. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
We'll put that one on hold for just a moment and go to 26 CR 752. And in 26752, in summary, it alleges that also on or about December 1st, 2025 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, which means a second-degree felony means that you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. In this case, you will be pleading guilty and sentenced to 5 years in prison to run concurrently with the other cases. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes.
You're pleading guilty voluntarily and because you are guilty.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 for each of these two cases, 26 CR 751 and 752. Did you sign those documents?
Yes, sir.
Voluntarily, understand them, discuss them with your attorney?
Yes.
Are the contents all true and correct?
It's true, sir.
Okay, State's Exhibit 1 is tendered into evidence in each of these cases. Without objection, it's admitted. And in each of these cases, State's Exhibit 1 similarly states that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer in each of these cases. All of this is true of States. So help you God. Correct?
Yes, sir.
State's Exhibit 1 is made a part of the record in each of all of these three cases. 26 CR 750, 751, and 752. And pre-sentence reports are waived?
Yes, Judge.
I never follow these agreements. The only thing that's a hitch in the giddy up, as it were, is that this 752 case, there's going to be an affirmative finding.
We understand.
That a deadly weapon was used, which means your parole is different. Going to be different from the other cases. You're going to have to serve by law at least 50% of your time before you are considered for parole.
Yes, sir.
In these two cases, 751 and 752, I find, Mr. Chavis, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. In State's Exhibit 1 admitted in each of these cases, I now find you guilty beyond a reasonable doubt of unlawful possession of a firearm by a felon, a third-degree felony in 751, and the second-degree felony of aggravated assault with a deadly weapon, 752. I am following these agreements. In each of these cases, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 5 years. All of these sentences shall run concurrently with each other. And in 752, an affirmative finding on the judgment will be reflected that in that case, a deadly weapon, namely a firearm, was used in the commission of the offense. All right. Do you understand what's happened on all of this?
Yes, sir.
All right. And again, these sentences run concurrently. Fix all of this. I know you can do better than this.
Yes, sir.
Do it.
Most definitely.
Do it. You can do it.
Mistakes happen. I apologize.
And you're given credit for it. You will be given credit for all time you've served in accordance with these cases. But yeah, yes, they will. And you have to know, this is like radioactivity. You got your firearm, and that's a crime. And that's another third-degree felony. You got to stay away from that.
Yes.
Okay. All right. Anything else? That is all. Thanks, Judge. To cross all the T's and dot the I's, there is a motion to dismiss in 26 CR 288.
Yes, sir.
Anybody object to me?
No, Judge.
You'll never get one of those from me in regards to a dismissal.
So I can just dismiss all day long then.
Absolutely, especially if they're my cases, Judge.
What is it? How far I can run around the neighborhood without getting in trouble. Okay, that case 288 is dismissed. Okay.
You're glad you had such fun.
This one. It was 2, 3, and 4. Corey Fontanet.
He's a please, little judge.
Corey Fontanet, please. Just one, please.
Just one.
Gotta be the probation.
No, it's a
Oh, 40, I'll be done.
That's about 44 has. I don't think you get our major probation.
She's gonna be pretty.
Okay, yeah, you sign in front of that little back here.
Right now, please raise your right hand. Where or on, so that we will put the hand positions up here. Okay, you got the right thumbprint.
I see what, can we,
What's it?
is it okay if we put 1 year?
Sure.
Rather than 12 months listed?
Okay, keep that one on.
Sometimes that, they go 12, and the months become the years
Okay.
on a 12
Sure.
sometimes. Where it's, they can't make a mistake on this 1 year. Well, they could, but should. All right, we'll call 26 CR 189, the state of Texas versus Corey Michael Fontanet. You, Mr. Fontanet. And you're here with Ms. McNally, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment thereof? Can we proceed in summary?
Yes, Judge.
In summary, sir, 2 paragraphs here constitute the state jail felony. In paragraph 1, this alleges that you committed the offense of theft of a value of less than $2,500. And then paragraph 2 goes on to allege that you have 2 or more prior theft convictions. 2 or more prior theft convictions mean that even if you steal a pack of gum from here on, it's a felony. So we're looking at a state jail felony. The way it is charged, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand the punishment range applicable in this case, sir? I'm looking at the agreement. There's an agreement that's been reached where you would be pleading guilty under section 12.44 of the Texas Penal Code and sentenced to 1 year in the county jail. Is that your understanding of the plan?
Yes, sir.
12.44 provides that a court may punish a defendant convicted of a state jail felony by imposing the confinement permissible as punishment for a Class A misdemeanor, which is up to 1 year in the county jail. And the court must consider the gravity and circumstances of the felony committed, the history, character, and rehabilitative needs of the defendant. And the court must find that such punishment would serve the best interests of justice. So what you're looking at is the disposition of this will be a state jail conviction under this plan, but it's punished as though it were a Class A misdemeanor. And is this your understanding of the agreement? If I follow this agreement, you have no right of appeal. Do you understand? So how do you plead to paragraphs 1 and 2 of this theft? The thefts in paragraph 1 and the prior 4 convictions of thefts alleged in paragraph 2. Are you pleading guilty and true respectively to paragraphs 1 and 2? Are you making those pleas of guilty to paragraph 1 and true to paragraph 2 respectively voluntarily and because those allegations are true? I'll tell you what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney, or the contents offer incorrect? State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by you or the lawyer. All proofs will help you guide. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived here. I will follow this agreement. Nothing further. I'm going to find you, sir, are pleading guilty to paragraph 1, the commission of theft, and 2, on the second paragraph, you were pleading true to the prior theft convictions. So paragraphs 1 and 2, the 1 theft, less than $2,500, is enhanced because of your pleas of true to 2 or more prior theft convictions. In paragraph 2, you pleaded to all 4 of your prior theft convictions. This constitutes a state jail felony, and the agreement is that you would be punished under section 12.44 of the Texas Penal Code as though it were a Class A misdemeanor. The court finds that this decision and agreement is in the best interest of justice, as the court has reviewed your history, criminal history, your character, and rehabilitative needs of the defendant. And the court finds that punishing you for a Class A misdemeanor under these circumstances would serve the best interests of justice. But once again, you would be convicted of the state jail felony. Do you understand what's happening?
Yes, sir.
All right. I hereby find you guilty beyond a reasonable doubt in paragraph 1, the theft, and 2, I find those allegations of prior theft convictions to be true. And you have pleaded guilty voluntarily, knowingly, intelligently. And State's Exhibit 1 is made a part of the record for all purposes, and that supports your guilty plea to find you guilty beyond a reasonable doubt of this state jail felony. I so find you guilty of this state jail felony of theft in paragraphs 1 and 2. I am following this agreement based upon the Penal Code, section 12.44. That is, if it is in the best interest of justice that you be found guilty of the state jail felony, but be punished as though it were a Class A misdemeanor. I so find that you are convicted of this state jail felony, and you are hereby punished for confinement in the county jail for a term of 1 year. You will be given credit for all time you have served in accordance with this so far. Do you understand what's happened today, sir? Anything else?
No.
That is all. Thank you.
Thank you.
Ashley Elvis Presley.
Close, Judge.
She's requesting that her case be set on the trial docket.
Where is she?
She's in custody.
Okay, let's bring her out and make sure she understands. Actually, president. So who's handling this for Miss Moore?
I am good. Thank you.
Yeah, this, we gotta be careful on this one, I think. Well, careful on all of them, but this is a new one. Come forward, please. All right, you are Ashley Ann Presley?
Yes.
All right, in 26 CR 65, you were here with Ms. McNally, your attorney, and the prosecution is here. As you know, you are charged with a most serious offense, a first-degree felony of trafficking a child for sexual purposes, is the way this is alleged. And this carries with it no less than 5 nor more than 99 years confinement in prison or life imprisonment. And a fine up to $10,000 can be assessed. Is there anything special about the punishment range on this day, or is it just that regular first degree or felony offense? All right. So it's, they don't get much more serious in the allegations than this. Ms. McNally is representing you. This is an announcement. How long have you been in jail now? Months? How long have you been in jail?
Since February.
February. Okay.
Yes, sir.
Well, it's going to move one way or the other right now. What are we going to do?
She's requesting to set her case on the trial docket, Judge.
All right. It's going to be set on the trial docket. Here's some things, though, that the court has to order, because this is involving a child as an alleged victim. You nor anyone on your behalf can have any contact with this child. I don't. I'm not saying you did, but I have to do the warning. If that happens, that's a crime, serious crime, and that gets stacked on top of trouble if somebody's got pending cases. Someone on your behalf as well. I don't want to hear that there's being pressure made on the child through someone else acting on your behalf. That would be serious for them, and possibly as well as you if you knew about it. We don't get over this. And that's a good thing because of the nature of it. the statute, we don't deal with this often, thank goodness, because the nature of it is so serious, but there are different variations of what the punishments can be based upon the circumstances. And is there anything that the defendant needs to know? It states under subpart B and small case B. It was indicted as large case A, but I think it's subpart. It's a small case because they've got large cases and small cases letters in the.
Judge, it's meant to be capital A2, but B1 that you're looking at describes the punishment range. It details that anything under A5, 6, 7, or 8 is the first degree felony punishment range that she's indicted under.
And she's under 8.
That's correct.
And it's small case A, not large case. It's large case A, but it's a small case. I don't think that affects anything. And that's in the caption anyway.
Small case A8, and then it's punished by small case B.
Because it doesn't, we're not talking about any of the circumstances that would fit a minimum 25 years. Correct. Is that right, everybody?
Just the first.
So it's going to be, again, no less than 5, no more than 99 years confinement of life in prison. Is the defendant eligible for probation under the statute?
She does not have any prior felony.
I know, but is this let's make sure it doesn't fall into one of those exceptions where there's probation is not allowed. I mean,
it would fall under, no, she would not be eligible for probation under 2802. There's no probation. It's under 42A.056.
of the Code of Criminal Procedure.
Yes.
Correct, Judge.
Is that what you understand too, that this is not a sentence, if found guilty under this, she's not eligible for probation, so she's found guilty, it's
prison time.
Prison time.
Yes, sir.
Is this also treated as a 50% rule if found guilty and imprisoned under parole statute?
That I don't know, Judge. That's a whole different animal.
Well, that affects a lot of decision making sometimes.
I mean, generally, if you can't give them probation on it, then it's usually a half time.
Folks, you know, put your phones on.
I think it's going to be in the government conflict, you're going to have to do it. Generally, if it's a 3G offense, what we used to call 3G on under 5.4, it's listed as one of those that you can't give probation on, which usually means it's aggravated.
Yeah. So also, your parole, if you are sentenced, the parole law may require you to serve any sentence at least 50% before you are parolable under this. So it's legislature intended it to have serious consequences. So we're setting it for trial.
Yes.
Oh, it shall be done. And again, be careful about communicating with the victim, the alleged victim. Yes, sir. Office. That's all. I have Pruitt.
Judge, he was found incompetent several years ago.
Said she was doing 30-day extension.
Yeah, we need to do an extension on him, for Ken.
Do we need this person out?
I don't even know if she's here.
All right, in 20-36015. Keith Andre Pruitt was charged with a second-degree felony of assault on a peace officer. Also, the indictment alleges a prior conviction out of the 252nd District Court of Jefferson County, Texas in 2009 for illegal possession of a controlled substance. So this second-degree felony, if can be enhanced to first-degree felony punishment if all paragraphs 1 and 2 are proven true beyond a reasonable doubt. And yeah. Zach. Okay. In this case, the defendant was evaluated for competency, and a report was sent to the court dated July 3rd of 2020. No, let me see that.
Last time we did this was August 4th of 2025. He was found incompetent, and we sent him away for a year because he's been incompetent since 2022.
And
It's fun.
okay. Where's the updated? Okay.
I don't have one.
We don't know.
I think that's why he was asking for the 30-day extension.
To get the paperwork.
To get the paperwork.
Judge, the state has no objection to the 30-day extension.
Defense either, Judge.
Okay. Because again, what the court has is,
Yes, sir.
the last order was August 4th, 2025, and this is coming up to the annual anniversary. So we're going to reset this for
30 days. If you could do an extension for 30 days, that would.
No, Judge.
okay. It is granted, but let's not bypass 30 days. Thank you. For a review for competency. Thanks. Deborah Wozniak.
Judge, she has expressed that she wants to voluntarily plead true to you and go to you for a decision on her motion to revoke probation.
Now, is that what she wants to do?
Yes.
Okay, well, I see Ms. Lawson.
I do have some things to put on the record before we get started. Judge.
No fun. Let's see, let me really consider it. She's been on probation for a while. Probation office is here.
Say you're dealing with a trial, okay? You say you're dealing with a trial. I thought so. And we can see you jumping up and wishing for something. Begging for more. Well, this isn't enough. We're still affecting with what horse. You know,
Just aside here,
where is the ball show?
we have a DWI. On or about April 22nd. What? This There it is, 422. What did this recent test show on intoxication level?
Judge, there was a breathalyzer that was administered, but she wasn't able to blow it enough to get a reading. I don't believe I don't have a.
Let's see, Judge.
Estimate for finding yes.
I've got some information here on the new offense. Let's see.
It says blood. It's absent
I
blood.
don't believe we have that back.
Schlotsky, we don't. We shoot.
This was in April of this year. I doubt we would have it this quickly.
What is the time period on these now?
Well,
They used to do 3 months. But
no, it's more like
yes.
About a year now.
more like a year now.
However,
Meanwhile,
Yeah.
people
if she's pleading true,
languish.
if she's pleading true to a judge,
Well,
I'll say there's information that indicates in this most recent offense, there was an accident and there were signs of intoxication, Judge. And an admission of consuming alcohol by the defendant.
two glasses of wine around 7:30 this morning.
Yes, sir.
A little early on the wine,
I had not slept at all in about a week. And I was pretty,
still a little early on the wine.
so
It's still a little early on alcohol.
Nevertheless, Your Honor, consuming alcohol in any form or amount is a violation of her terms of probation.
All right. We call 21-37954, the state of Texas versus Deborah or Wozniak. That's you. With Ms. McNally, your attorney and the state's attorney is here. And raise your right hand, ma'am. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Okay, Lord.
Judge, if I may put a few things on the record before we
Yes.
begin. Ms. Wozniak, you understand that you have a motion to revoke probation pending, correct?
Yes,
And you were put on probation for a third-degree felony, DWI third, isn't that right?
yes,
And you were put on something that we call straight probation, but it means you've already been convicted of the offense, correct?
yes, ma'am.
And then you and I have discussed how we can resolve these motions to revoke probation. One of the options is to have a contested hearing about the violations where the state calls witnesses. Is that correct?
That's correct.
And then we talked about how you can waive that right to have a contested hearing and you can proceed to the judge or agreed with the prosecutor to the judge to resolve your case. Is that correct?
Yes, ma'am.
Do you want to waive your right to a contested hearing today?
I do.
And we have talked about the offer that was on the table from the prosecutor. Are you choosing to refuse that offer today?
May I say something in addition to yes or no? At 73 years old, 5 years might as well be 10 years.
Yes, ma'am.
So are you rejecting that 5 years?
I am rejecting the 5 years and I'm going to leave it up to you, sir.
Okay, so you understand that by waiving your right to have a formal hearing and rejecting the offer from the prosecutor, that Judge Stevens is going to be the one to decide whether or not to revoke your probation. You understand that? And then if he decides to revoke you, then he will decide what your punishment would be. And that can be up to 10 years in TDC. Okay.
knowing all of that and discussing all of this with your attorney, do you insist on moving forward today without an agreement? And again, letting the judge make this decision.
I'd like to know today, one way or another, so that my mother's estate can be probated and resolved.
Yes, ma'am. Okay. So that means, yes, you want to move forward.
Yes, I do.
All right. All right. Can we proceed in summary? In summary, Ms. Wozniak, this motion to revoke probation in cause number 21-37954 states that on December 6th, 2021, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison, and that was suspended. You were placed on regular probation for 10 years for committing the third-degree felony of operating a motor vehicle while intoxicated. And this was a third-degree felony, as you pleaded guilty to paragraph 1 of this indictment, committing the offense of operating a motor vehicle in a public place while intoxicated. And then paragraph 2 alleged that you had 2 or more, you had 3 total, but 2 or more prior DWI convictions. The first one in time out of Galveston County, Texas, in County Court of Law 2 on July 13th, 2006, in cause number 244463. Thereafter, in Chambers County, Texas, County Court, in cause number 24031-05 on March 1st, 2006. So that's the same year on a different date. And then a third DWI conviction was alleged that you apparently pleaded true to that occurred on May 24th, 2018. That was a conviction on that date in 241-200-18 out of the 241st District Court of Smith County, Texas. So there were 3 prior DWI convictions.
Yes, sir.
Alleged. And then this new one that was committed on or about January 2nd, 2021. And then you were sentenced to 10 years imprisonment. That was suspended for 10 years probation. And then this motion to revoke comes along, and all of this is true so far?
Yes.
Allegation 1 in the motion to revoke probation filed on May 6th of 2026. It states you committed the offense of operating a motor vehicle while intoxicated, a third-degree felony, on or about April 22nd, 2026 in Jefferson County, Texas, which would be a violation of your probation order, condition 1, which states commit no offense against the laws of this state or any other state of the United States. Is that allegation true or untrue?
It is true, sir. I'm not going to lie to you.
Are you pleading true voluntarily and because it is true as it is alleged?
2 different. Yes, sir.
Okay. Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that would be enough to grant a motion to revoke probation? Your probation can be revoked and you can be sentenced to no less than 2 nor more than 10 years confinement in prison.
Sir.
Knowing and appreciating that, do you insist on pleading true today?
I have to. It's the truth. Yes, sir.
I find then you are pleading true voluntarily and because it is true, and you are expressing a willingness to accept responsibility. Anything, do we need to go on any of these others?
Your Honor, the state would abandon number 2. However, we would respectfully ask, we would abandon number 2. Number 3, we would respectfully ask to go forward on number 4, please, as well.
Okay. Allegation 4 states that you failed to have the auto ignition interlock system installed in your vehicle as required by the probation order, which is order number 36 of your probation order. Have an auto ignition interlock system installed in any vehicle you may drive and pay all associated costs. And this says you failed to honor that requirement on or about on April 22nd, 2026, at the time of your arrest when you were operating a motor vehicle. Is that allegation true as well?
It is true, but there were some extenuating circumstances, but in the end, that is true.
Are you pleading true voluntarily to allegation number 4? And because it is true as it is alleged?
It is true.
And again, do you understand that one or more violations of probation, all it takes to result in a revocation of probation if found by a preponderance of the evidence or greater? Again, your probation can be revoked. You can be sentenced to no less than 2 nor more than 10 years confinement in prison for a violation of allegation 1 and or 4.
I fully understand.
Knowing all of that, do you insist on pleading true to allegations 1 and 4 of this motion to revoke probation?
Sir, I have to. It is true.
All right. I find that you are pleading true voluntarily, knowingly, intelligently. And because you insist these allegations are true as they are alleged. Okay, go ahead. Anything the defense would like to add on this?
Say,
Yes, ma'am.
at that point.
Okay, remember, you're still under oath, and you can do a question and answer if you want, or
Yes.
allow her to make a presentation. All right. Ms. Wozniak, when you're ready, go ahead. Yes, ma'am.
I was in the middle to end stages of liver failure, which creates some questionable judgment.
Hold on, I'm going to ask questions as we go.
Okay.
This liver failure, I'm familiar. Liver failure can occur with alcohol usage.
Yes, and that is
Was that the?
Sorry, I didn't mean to do that.
Was that do you, from your doctor's reports, was that the cause of liver failure, alcohol abuse?
Yes, sir, it was. And I was later hospital, or right immediately after that, I was hospitalized, considered near death, then went through 2.5 weeks of rehabilitation, physical rehabilitation, and my liver failure is under control at this point in time.
Good. Good for you.
But I really do think I was advised by my physician that would impair my judgment.
Okay. When did you get a good prognosis on the liver?
It's hazy to me when I went to the hospital. I think I was hospitalized at Baptist that day.
Which day?
The 22nd.
April 2026, when these new allegations she's plugged through.
When I was driving without the interlock device in my car. I felt like
You was arrested.
Yes.
Okay. You bonded yourself out, or you were?
She's in custody, Judge.
I was.
How did she get to the hospital? That was
They
before she was
usually
arrested?
seek medical treatment as part of a DWI arrest. If they're showing signs of necessary medical treatment, they'll
Okay,
usually bring
it
them
was
to-
from that arrest, then you were submitted to the hospital immediately?
Yes, sir.
Okay, how long did you stay there?
Probably about 3 days.
And then you were transferred to jail from there?
No, I was transferred to a physical rehabilitation
For how long?
for 2.5 weeks.
And then what happened?
And then I was released on a Saturday. On Monday morning, it was June 1st, I came to jail.
Okay, how did you get to jail?
I went to my probation. My sister took me to the probation officer, and there was a warrant with
Had been
a county
ready
officer,
to go.
and he took me.
Okay, and you've been in custody ever since?
Yes, sir. Over
I
60
see,
days.
112 days.
Mhm.
Okay, go ahead.
For what it's worth, I don't know if this makes any difference or another, but I did.
Everything's important.
I have fallen several times, and that is one reason why I'm confined to the infirmary. And I did fall, I had some staples in my head by the Jefferson County Medical Department. They did a good job, but I did injure my shoulder, and I have very limited movement of my shoulder, and they cannot treat that in this facility.
And then, Deborah, I think that there were some circumstances surrounding your mom's estate and your mother. Do you want to talk to Judge about that situation?
My sister is the executive. My mother did die. I became her sole caretaker for the last year, and that was what kind of put me in a depression and kind of got me spiraling downhill. My sister, who is in the gallery right now, she needs my cooperation to probate the estate.
What do you mean?
Sell the house.
What kind of cooperation are you going to need to?
Probably just some forms being signed. The house needs to be sold, but she can put that on the market. I will have to find another place to live, but that is provided for in a trust for me.
Do you understand? You have obviously been very thoughtful about how you want to negotiate through this. And of course, your attorney is a fabulous lady who takes in. I'm not just saying that because, but she is. She's earned a great reputation as a young lawyer who's precocious as being a great lawyer already. But do you understand? We put you on probation, and this is while on probation, when you commit another similar offense, the likelihood of this court seriously considering putting you back on probation is slim. Do you understand?
I understand, sir.
And so the punishment range for revocation, if it's not being placed back on probation, is no less than 2 nor more than 10 years confinement in prison.
Yes, sir. And at my age, I would like to avoid confinement, but I understand that that is necessary. I would just like to keep it to a minimum at my age. I just turned 73.
Well, I can tell you from my vantage point, that's not all that old.
Well, I probably.
But I'm running 5 miles every day too, and I'm about your age. But it's a different set of circumstances.
Probably one of the healthiest people in the
Good for you.
in Jefferson County.
Well, I hope you live a long, happy life.
Mhm.
But most importantly, this is, I don't have to tell you, this indictment that you pleaded guilty to had 3 prior convictions of DWIs. Then you pleaded to a fourth.
Yes.
And essentially, a motor vehicle is essentially a 4,000-pound missile. And all too often, cases are in this court where you've got a group of people weeping over their victim who was injured, seriously injured, or died in a crash with somebody in irresponsible operating a motor vehicle, a 4,000-pound missile, and you can't bring life back. And you've been subject to felony punishment, what, 2 convictions ago? Okay. So whatever happens here, nonetheless, you have to be completely clear of operating a motor vehicle, because the next one would be a more serious crime.
I do not plan to operate a motor vehicle anytime in the future.
Just do it responsibly and soberly. That's, because they come in handy as a tool to move them for mobility. But still, we make a covenant with all others when we're operating on the roads that we will care not only for the safety of ourselves, but safety of other fellow motorists. And like I say, we get cases here all too often, and there's weeping and crying, and they want their loved one brought back. And it always seems like the person who's victimized and killed is like a child or somebody who is just a angelic person. And it happens over and over again. And those circumstances result in serious responsibility for the people. And you got Mothers Against Drunk Driving that I'm a supporter of. Those people, and they do a great job on trying to educate the public on the responsibility and the importance of appreciating others' lives so that we can operate motor vehicles safely on the same roads, because it seems like speeds are getting higher. But nonetheless, the accident rate is still, I'm afraid, increasing. So all of that is part of this equation, and your recidivism, it plays into the determination of what's appropriate. You understand?
It should.
What do you have if the court sentences you in the lower range? What do you intend to do to ensure all of us, others, that you will not fall back into a bad choice in getting into a motor vehicle while intoxicated?
My medical situation has definitely changed. The liver failure, I can never drink again. I'm going to liver failure. The fact that I do not live with my mother anymore, she kind of let me do whatever I want. I feel like if I can get back into the community within a certain age range, I've volunteered down at some other place doing Meals on Wheels for over 12 years now. And there are people in their 80s delivering meals. Joe Parigi needs somebody to ride with him. I feel like, and I do a lot of volunteer and church work, and I feel like I can still contribute to the community even at my age, because I am able. I said I'm probably the most able-bodied person in my medical infirmary at Jefferson County. I just really feel like I'd like to make a contribution to society, and I can't do it like that.
No, but a felony offense can pretty much neutralize all those great intentions and good works. And you've had a felony here, and the next one is another felony, even more serious if it happens. Then you don't jump right into a felony on a DWI unless there's a injury or a death. A DWI takes 2 priors to get to a felony, and we passed that a couple ago. All right. What are we asking for?
Judge, she's here voluntarily accepting responsibility. She knows what she's dealing with. She's aware of the issues that she has faced, and she has told you of those issues, and she has pled true to those today. She is an avid member of the community. She wants to continue to be an avid member of the community. I also think that something to focus on would be to rehabilitate her from this alcohol use that she has succumbed to for so long, which is represented by the several past DWIs. The only way to monitor that progress and to ensure that she is holding up her accountability that she's taking in front of you today is to put her in some sort of a program that encourages that rehabilitation, and to put her back on probation to ensure that she is being monitored and she is accepting that accountability and that responsibility like she's told you that she will today. So we're requesting for some sort of reinstatement with maybe some heightened condition toward rehabilitation. If that's not something for the court to consider, then we would be requesting two.
Okay. Go ahead.
Thank you, Your Honor. I'll be brief because the court's already touched on the argument or arguments I was going to make about the community safety.
Let me ask, not to interrupt you, but what was the offer that had been made by the state to resolve?
5 years TDC, Judge. Your Honor, again, it's admirable that this defendant is being sincere, and I believe she's being sincere. It's admirable that she is taking responsibility, Judge. However, if one thing I'd like to point out is that if you look at the underlying offense, there was a motor vehicle accident involved in that DWI offense, Dowling Road and Gladys. You look at the new offense, Your Honor, there was another motor vehicle offense involved, Delaware and Dowling.
You said motor offense involved.
Yes, motor vehicle. Well, at least that's what's in the issue. They can respond if they like have a judgment. But my point is, we often speak, and prosecutors and even as judges, we got one of the people behind we speak in conjecture, speculation that someone can get killed. Your Honor, we got 2 instances here where it's not section down in the books. That's all I'm saying is that her current situation is
Anything else you would like to add?
The accidents were minor. There were no injuries. I don't think that makes much difference, but I
Grace of God has a lot to do with that.
that I would like to clarify. And the first one was just, it was grazing a car. It was not an accident. That shouldn't matter. I shouldn't have been on the road.
From probation, anything you would like to add to help the court on this?
I stand with the 5 years of TDC.
Ma'am?
The thing is, I stand with the prison time for TDC for 5 years. But the thing is, like, while she's in there, that will give her time, her liver time to heal also. And extremely common.
Parties are positioned with the state urging their offer of 5 years be accepted by the court, and then the defense requesting that the defendant be placed back on probation. The court is going to hear your motion to revoke probation is hereby granted. And Ms. Wozniak, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. It's less than what the state was asking. It's not what y'all are asking. And you will the parole people will be making a decision on when you will be released. You have credit for 112 days, but we can't bypass the seriousness, the continued seriousness of the operating of a motor vehicle, which results in one of the highest percentages of loss of life and injury in America. It has to be operated responsibly, and you have had far too many DWIs. And I can say that if you get well and get out of prison with good behavior, when they decide it's probably, you still have a long life of time to go, as long as you don't continue to harm yourself by alcohol abuse, which is where I hear from what you're saying is the problem health-wise. But this is the most serious type of offense when it's in our court, because that means 2 or more prior convictions. And in this one, there's one more than that in your case. So you have to pay a price. And this court finds that under these circumstances, this may not be what you were hoping for, but what the court finds it is fair and just under your criminal history. And also this gives an opportunity for you to get parole when you're ready. And during the parole term, they're pretty good about making sure that you follow terms and conditions that are relevant to the problem that you were placed in prison for. So they will help you when you.
So we'd be eligible for parole before the end of the 4 years?
Yeah, this is one of those where you are, you can be eligible in a quarter of the time, but again, it's parole decisions. Those are for other authorities to make, not us. None of us in this room have the authority. We can just say what you can be subject to and when you are eligible, but the other parole authorities make the final call. And I would urge you to make sure when you deal with them to get all your thoughts about what your plan is in assuring parole authorities that they're convinced they can trust you when you are released, that you will not fall back to alcohol misuse and then jumping into a car and putting people in harm's way. All right. Anything else on this?
No.
Okay. Good luck to all of us here. Thank you.
Thank you.
Christopher Elam. That was for Bruce Smith, and he's not here, is he?
Yeah, I am here.
Oh, there's Bruce. Come on up, Bruce. What are we going to do?
So if that's been the case, we place some dollar after them. Hello. See you. You need to
No, doesn't look like it. Okay. Shall be done. Next is Messiah Davis.
Judge, I'm still working on that case. It's pretty new to me. You just need to reset up. It's the same move. Davis, we're just asking for a reset, so.
I'm applying to do that.
Okay.
It's just, yes.
Okay. Set for an announcement today. We're gonna, what are you, 3 weeks good?
Yes, sir.
It is reset 3 weeks. Announcement, Carlina Solomon.
It's a plea judge.
Solomon?
Yes, sir.
Daniel Berry, am I giving that back to you? Thank you.
So working this one out.
I had a couple that we
Workable offer.
it didn't work. Okay, I've got Carlina Solomon. What is this on Dagan Ruts? 23 CR17.
To say, I prepared a motion to dismiss, Judge. I put the reasoning on that motion.
Oh, okay, there's not another case to be pleaded to. It's just that you're going to dismiss it.
Yes, sir.
Good. Okay. Thank you.
Raise your right hand. You swear or affirm to yourself and God.
All right, 23 CR 1791, the state of Texas versus Dagan Rux, RUTZ. That case is hereby dismissed. I have a G-Con Butler and Daryl Cooper. What happened on those?
Butler was the plea with Mr. Laird that did not go through the temporary, I forget the term he used, temporary. Bit of
The defendant said.
temporary psychotic episode. 85-year-old elderly victim, temporary psychosis.
And Daryl Cooper. Who had Daryl Cooper was a state champ. I didn't see that.
He was the one in the wheelchair.
It was signed for Don, it was Don Deucer.
That's the one that, Judge, we just had an NCRP come down on that, so we.
So we put it in hold. Yeah. All right. And so Marlena. That's you? Cross number 24 CR 1361 is called the state of Texas versus Carlina Solomon. Does the defendant waive a formal reading of the indictment and the arraignment? Mr. Turk, as your attorney, can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about April 15th, 2024, in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with a deadly weapon. Do you understand what you're charged with? And this deadly weapon was a knife.
Yes.
If convicted of a second-degree felony such as this, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached in your case where you would be pleading guilty and sentenced to 10 years in prison.
Yes.
Then that would be suspended. We would place you on regular probation for 10 years. You would be fined $1,500. There would be other terms and conditions of probation, which are normal and customary for this type of offense and also for the circumstances of this case. And this says, stay away
From Prince Hall Apartments, Judge.
from Prince. You will not be allowed to get near Prince Hall apartment. You're in MoMA. Is that your understanding of the agreement?
Yes, sir. And Your Honor, sorry to interrupt the court. If I
That's
may,
okay.
if I may, please, Your Honor, I at least want the court to know and the record to reflect that the state's offer, while this is a very serious offense, the allegations are very serious. The state's offer reflects the fact that she's 18, or at least 18 at the time, with no criminal history, and she has already served at least 63 days in jail, Your Honor.
All right. Is this your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this second-degree felony, aggravated assault with a deadly weapon? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of this? I'll show you what's marked as State's Exhibit 1. Did you sign this?
Yes.
Understanding. Discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered into evidence. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with when the indictment's been read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to an appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation by Mr. Turk for you. All of this is true. It states so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
I am going to follow this agreement. I am going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this aggravated assault with a deadly weapon. I am going to follow this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of
Your Honor, sorry to interrupt again. Can we even do a straight probation on this? I know I made the offer, but now that Now that I think
I
about
thought
it,
you could, I think you can do it in front of a jury, huh? Or, hold on, stand by.
I'm thinking, I thought, okay, and so.
I don't think we can.
Deadly weapon, no. Would have to be deferred.
Just the allegation is very serious, Judge, which is why I was kind of, my tendency was for a conviction.
I don't even think you can do a shot.
No, can't do a shot because
That's what I'm
can't
saying.
give probation.
Uh-huh.
Fair probation.
Just for the court's information, the allegations are that there was a noise complaint at the Prince Hall Apartments. The resident came out and engaged this defendant. She stabbed that resident multiple times.
Well, it's a bit reductive, but it's, that's a bit reductive.
It's a summary. It's my summary, at least.
All right, well, I wish I could find something else, to dispose of it. What do you want to do right now?
Can we have a moment to confer, please, Judge?
Go ahead.
Sure.
Clean it up. I did see my big one there. I haven't heard back from it. You can still get a shot of the
You would do this once I started shutting down all the tablets. No, you do best.
You do anything? No, sir. I think this is the last, yeah. Last thing. Yeah. And you try.
Redo the paperwork.
Yeah, you have to ask the judge. I think we may have to redo it.
Well, are you all change it from 35?
Yeah, but we're 180 days up.
You can erase it up there.
Judge can change it.
Yeah, so we don't have to do all that again.
Thanks.
Make it easy.
Sorry about that, Judge. I always forget about that court and all the law.
We'll define it.
63 days.
You still got that place with my watch, right?
Glad you caught him.
Yeah.
Look, I don't have a problem doing that. Positioning this to a deferred or unadjudicated probation. It's simple enough to do this. But the circumstances, let's say, the victim sustained stab wounds to his left shoulder, chest, and right leg, causing serious bodily injury. Several subjects were outside his apartment, causing a disturbance. Well, he confronted them, of which he had every right to live peaceably, about the noise, and the defendant approached him in an aggressive manner, stabbed him with a kitchen knife several times, then fled the scene. I don't have a problem placing him on deferred or unadjudicated, her on deferred or unadjudicated probation if that's what the state wants. But 63 days is
We
not.
would address that. We would address
Agreed to 180 days.
Oh, okay.
That's what we're coming to tell you.
Because you don't stab.
No.
So they're trying to live peaceably, and they get if we're going to put you on deferred, you're going to also be subject to the most lengthy jail time as a condition of probation that we can assess for this, because this is preposterous. People shouldn't have, they have a right to live peaceably, and by them complaining that their home was living in their home was disruptive because of what kind of shenanigans are going outside to be disruptive, then they shouldn't expect to be stabbed just because they had a rightful complaint, because he pays rent or lives out there in some way, but he's paying.
Your Honor, if I may add, that the state has sent a letter to the victim of LeVar Menifee. It's what I refer to as my standard victim letter, asking him to contact our office and discuss the case. To date, that letter has not come back undelivered, and to date, we've not heard from Mr. Menifee. I just want to put that on the record.
Well, I'm going to ask the probation office to send something to the victim to find out, to get input from the victim on his damages, please. Care about the victims. Shouldn't have to be victimized. But when they are, there's a price that's paid. Okay, and 180 days, where were we? Let's see. You got here, stay away from Prince Hall Apartments. We're going to also put 180 days county jail.
Yes, sir. Yes.
As a condition. Okay. And there's really no place to put this up, but I'm going to put it right after it. Yes. All right. Is this your understanding of the plan then, that you would be you would be placed on deferred or unadjudicated probation for up to 10 years in length? And you would be fined $1,500. There would be terms and conditions of probation, which are normal and customary for this type of offense. You will be required to stay off of Prince Hall Apartments property and serve 180 days in the county jail as a condition of probation.
Yes, sure.
And the other terms and conditions of probation as well. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked as State's Exhibit 1. Did you sign that, understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered.
No objection.
Without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I will find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. As you plead guilty to the second-degree felony of aggravated assault with a deadly weapon, there's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt from State's Exhibit 1 admitted. But I am going to follow the recommendation and the agreement here by the parties. We will place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, normal and customary for this. You must successfully complete an anger management program and pay all associated costs as part of your probation. Must stay off the Prince Hall Apartments location here. That's in Beaumont.
Put out there.
Okay, sorry. It's all apartments, Port Arthur, Texas. And there will be other terms and conditions of probation, which include you must serve 180 days in the county jail. Make sure you follow these requirements, ma'am. If you fail, your probation could be revoked. You could then be found guilty and sentenced to no less than 2 nor more than 20 years confinement. Knowing that, pay attention to following those requirements. All right.
Yes.
Anything else? That is all.
Thank you.
What else? What else? Anything else?
Nothing from the state.
That's it. We're in recess. Thank you.
Do you have any idea how to work that? I don't. It's what I'm sure.
Here, ma'am. Thank you.
Well, I'm gonna need it. I'm not gonna need. I'll need it for the presentation of my case. I'll cross that with you. Yes. No. I said you think mine does. It's very straightforward. Yeah. All right. Thanks. Still no saying.
Here's this right here.
No, now you're not.
But okay, I'm the one.
What?